recording.
Good afternoon, everyone. Thanks for joining us this afternoon for our webinar on COBRA Basics with an Affordable Care Act twist. I'm Lynn McGuire, and my colleague Tom Shaevsky will be joining us today as we talk about this topic. Our contact information is provided on the presentation in front of you. A link to the recording of this webinar is going to be available on the Butzel website. And there's also going to be a copy, in fact, there already is, a copy of this presentation.
The broadcast is now starting.
All
attendees are in listen-only mode.
At the end of this presentation, we'll try to take questions, time permitting. But if you submit a question, we don't have time to get to your question, we'll promise we'll follow up with you afterwards. We are providing slides that cover all of the COBRA basics. But in the interest of time, and since many of you already are familiar with some of these basic rules, we're going to skip discussing some of the items that you see up on the screen so we can get to the more helpful issues in the presentation. And again, our contact information is on the screen, on the first screen and the last screen, so feel free to contact us afterwards as well. Now my colleague Tom Shaevsky is going to start out with the basics of what is COBRA.
Thank you, Lynn. So, as Lynn says, I'm going to talk about the basics of COBRA, but please make sure to stay tuned to the second part, and particularly towards the end of today's presentation, as Lynn will talk about the healthcare reform aspect and its impact on COBRA, and specifically she's going to provide some concrete real-life examples. So again, that's towards the end of the presentation. COBRA stands for the Consolidated Omnibus Budget Reconciliation Act of 1985. We're going to talk today about COBRA as the federal statute, but I want to mention that some states have their own state law versions of COBRA. Sometimes people refer to those as mini COBRA statutes. Michigan does not have its own mini COBRA statute, but in other states, that's just something to keep in mind, that those state statutes could apply along with the federal COBRA statute. So what is COBRA? It's the continuation of existing group health plan coverage for certain employees, former employees, covered spouses, and dependents who lose eligibility for coverage. It's contained in the Internal Revenue Code, the Employee Retirement Income Security Act of 1974, otherwise known as ERISA, and the Public Health Service Act. Which employers are subject to COBRA? An employer that employed 20 or more employees in the prior plan year, is subject to COBRA. And the measurement period for that, you look at least 50% of typical business days. Part-time employees count as fractional full-time employees. And we provide on the screen there some transitional rules. As I was saying a moment ago, even if an employer is not subject to COBRA, the federal statute, be aware of state statutes. As I said, Michigan does not have a state equivalent of COBRA, but there is a provision in the Michigan Insurance Code requiring plans to notify individuals who experience termination of employment of their right to an individual conversion policy. So I would suggest that if you have a fully insured plan, that you communicate with your insurance carrier and make sure the carrier is providing the notice under this Michigan Insurance Code. One very important aspect of determining whether this 20 or more employee threshold is satisfied is the concept of controlled group. You may be familiar with this concept. It pertains not only in the COBRA context, but also with retirement plans. So let's provide a specific example. So here in our example, the U.S. corporation is a wholly owned subsidiary of a non-U.S. corporation. The U.S. corporation employs only 10 employees. So you might think, well, just looking at that one single entity, it's not subject to COBRA because it only has 10 employees. But in our scenario, the non-U.S. entity employs a fairly large number of individuals, 500 employees. In this case, when determining whether the U.S. entity is subject to COBRA, you look not only at the number of employees of the U.S. entity, but the foreign parent corporation in our example as well. And in this scenario, the U.S. entity is subject to COBRA. What benefits are affected? As you can see, quite a few. Medical, you may be familiar with being subject to COBRA, but don't forget dental, vision, and significantly, and Lynn's going to talk about this in her presentation, health flexible spending accounts and health reimbursement accounts, as well as some employee assistance programs. And here we provide on this slide a list of benefits to which COBRA does not apply. Again, I'm going through some of these slides quickly, so there's ample time for Lynn's discussion, in particular her real-life examples. Again, Lynn's going to talk a little bit more about health flexible spending arrangements and health reimbursement arrangements. There's 3 separate COBRA notice requirements. There's the general notice, there's the summary plan description, and then there's the notice of right to elect COBRA following the qualifying event. And I'm going to talk about each one of these disclosure requirements separately. So the initial notice of COBRA rights and responsibilities. This must be provided no later than 90 days from the date the employee and spouse first become covered. We recommend this be mailed first class to the employee's home and addressed to both employee and covered spouse if the employee is married, if they share the same address. If they have different addresses, then a separate notice should be sent to the spouse. Now, one question you might have is, what about same-sex spouse? And the answer is, if the plan covers a same-sex spouse and the same-sex spouse loses coverage as a result of the qualifying event, then yes, the same-sex spouse should be treated the same as the opposite-sex spouse for purposes of COBRA rights. Here on the next couple slides is a list of information that should be provided in the general notice. Again, in the interest of time, I'm going to not indicate what's on the slides, but as Lynn stated, this information is available on our website. The entire presentation is available. Now, why is it so important to provide the general notice? If the general notice is not provided, the individual's right to elect COBRA is extended until after the general notice is actually provided, which could be many months after COBRA rights would otherwise expire. So it's critical that this general notice be provided. A lot of times people say, well, the information's in the summary plan description that the employer is providing. Why doesn't that suffice? And the answer is typically the summary plan description is only provided to the employee. It's not provided to the covered spouse. So even though the second disclosure requirement we're going to be talking about is providing the information in the summary plan description, in many cases, unless you're talking specifically about the employee, it's strongly recommended that this general notice be mailed and do not rely on the information being contained in the summary plan description. Summary plan description is a requirement for plans subject to ERISA, and we indicate on this slide the information that must be contained in the SPD with regard to COBRA. Here's a cautionary note. Make sure that you have an SPD for each of your benefits that are subject to COBRA. So you might think, well, I have a summary plan description for my group health plan, but if for example, you have a standalone dental or vision plan or separate insurers for those programs, make sure that the insurer is providing a summary plan description which contains COBRA language. That's something we can certainly review on your behalf. If there is no SPD, one document you may be familiar with, which contains not only COBRA information, but a wealth of required information regarding welfare plan statutes and rules in general, is called a WRAP, W-R-A-P, a WRAP document, which can be used when different insured or even self-insured programs are involved. And the WRAP document can contain the COBRA disclosure information. Now, what are the qualifying events? For an employee, a qualifying event must result in loss of coverage and be a result of termination of employment other than for gross misconduct, and we'll talk about that in more detail shortly, or reduction in employees' hours of employment. So many people associate COBRA with an employee having a termination, with an employee having a termination of employment, but it can result in an employee, say, switching from full-time to part-time status, for example, and as a result of that change in classification, the employee loses coverage under the group health plan. Even though that individual is still employed by the employer, that individual may be experiencing a COBRA qualifying event. What does loss of coverage mean? It means an individual not covered under the plan under the same terms and conditions as immediately before the qualifying event. So here's a little question with a healthcare reform gloss. What happens when an employer uses using Affordable Care Act? And by Affordable Care Act, ACA, we mean healthcare reform. Some people refer to it as ACA, some people Affordable Care Act, some people call it Obamacare, some refer to it as PPACA, Patient Protection and Affordable Care Act. All those terms, for purposes of today's discussion, are referring to the same statutory regime. So what happens when an employer using the ACA look-back measurement period determines the employee is no longer full-time and therefore is no longer eligible for group health coverage after the end of the current stability period? Answer: COBRA eligibility is triggered. For a covered spouse or dependent, a qualifying event must result in a loss of coverage and be associated with the covered employee's termination, other than for gross misconduct, which we'll talk about, the covered employee's reduction in hours of employment, the covered spouse's divorce or legal separation, the covered employee's death, the covered employee's entitlement to Medicare, or the dependent child's loss of dependent status, meaning that because of the dependent child's age, the dependent child is no longer covered under the group health plan. On this slide, we provide some information about the Family Medical Leave Act, commonly abbreviated as FMLA. The start of FMLA leave is not a qualifying event. Instead, the COBRA qualifying event occurs on the last day of the FMLA leave if the employee, spouse, or dependent covered under the plan before FMLA was covered under the plan before FMLA leave began, and the employee does not return to work after the leave. And we provide more information on this slide about the interaction of COBRA and FMLA. The reason for the employee's termination or reduction in hours is not relevant. Again, it doesn't matter whether it was voluntary or voluntary, with the exception of gross misconduct. The modification or termination of a plan is not a qualifying event, even if it results in loss of coverage. So if the employer is modifying the plan, there's an amendment to the plan in a way that results in loss of coverage for a group of employees, that is not a qualifying event under COBRA. And in some cases, Chapter 11 bankruptcy of the employer is a qualifying event, but only for covered retiree, spouse, and dependent. So again, the key is it's a covered retiree. And again, we provide more information on that scenario. What about gross misconduct? Well, one thing to verify, I should say, is to make sure that the plan document contains an exception for gross misconduct. Don't just assume that you can exclude from COBRA coverage an employee who was terminated due to, in your mind, gross misconduct. The plan document has to contain this exception. Gross misconduct is not defined in the COBRA statute or in applicable regulations. So it's really defined as a result of court cases and case law, which means there's no bright line rules. Generally speaking, gross misconduct is not ordinary negligence, incompetence, or poor judgment. It usually can be dishonesty-related criminal conduct and sometimes is violation of employers' rules. Even though other statutes, for example, state unemployment compensation laws, might use the same words, gross misconduct, even though the same words or terms are used, they don't necessarily have the same meaning. So this is a really tricky concept, and we recommend that you consult legal counsel before deciding not to provide an individual with the right to elect COBRA because you believe the individual was terminated for gross misconduct. Who is a qualified beneficiary? A qualified beneficiary must be an employee or former employee, including a retiree, or spouse or dependent child of an employee or former employee, and have been covered under the plan on the day before the qualifying event. So if someone was not covered under the plan before the qualifying event occurred, that person is not considered a qualified beneficiary. Now, with so many areas of the law, there's a general rule and then there are exceptions. So here are some of the exceptions. What about an individual, a former employee who's currently on a COBRA status and gives birth to a child, adopts a child is placed with that individual for adoption? That, for lack of a better term, after acquired child can be covered under COBRA, even though that person was not covered under the group health plan the day before the qualifying event occurred. Qualified beneficiaries does not include domestic partners and adult dependents, and as I was saying a moment ago, individuals eligible to enroll but not actually enrolled on the day before the qualifying event. So here's another exception to the general rule of someone has to be enrolled in coverage on the day before the qualifying event. What if an employee is about to get divorced and decides to be a little sinister and remove the soon-to-be ex-spouse from coverage under the group health plan? In that scenario, the employee has canceled coverage of the soon-to-be ex-spouse in anticipation of the qualifying event, which in this scenario would be divorce. So for purposes of COBRA, this removal of the spouse from coverage in anticipation of divorce is disregarded, and the spouse, or the soon-to-be ex-spouse, would be considered as covered under the plan as of the day before the qualifying event. And in this example here, we provide the time frame as to how it would work in terms of the COBRA regime, ignoring the cancellation of coverage for purposes of COBRA coverage. What about notification requirements after the qualifying event? Well, the employer has the duty to notify the plan administrator within 30 days of certain qualifying events: the employee's termination, the employee's reduction in hours, the employee's death, Medicare entitlement, or the employer becoming subject to bankruptcy. Here on this slide, I think you'll better understand why there's the reason for that initial notice I was talking about earlier. You might think, why in the world would someone, upon becoming enrolled in a group health plan, have to receive an initial notice about COBRA rights, which really you could say would come towards the end or near the end of their participation in the group health plan? And the reason here is, one reason I should say, is that the initial notice explains to the enrollees under what circumstances do the qualified beneficiaries have to provide notice to the plan administrator. Otherwise, how else would these people know that they're supposed to provide notice under these circumstances? So a qualified beneficiary, not the employer, but the qualified beneficiary, has the duty to notify the plan administrator of certain qualifying events: divorce or legal separation, or loss of dependent status. And the qualified beneficiary has to provide this notification to the plan administrator within 60 days after the latest of the following: the date of the qualifying event, the date the qualified beneficiary loses coverage due to the qualifying event, or the date the qualified beneficiary is informed through the summary plan description or general notice of responsibility to provide the notice. Again, this is why it's critical that that general notice, the initial notice, be provided, because otherwise, if it's not provided, then the 60-day time frame is extended until the time the general notice is actually provided. So here's an example of the qualified beneficiary having to provide notice. The employee's divorced March 15th. The spouse loses coverage March 31st. The notice by the spouse is due no later than May 30th, 60 days after the later of the qualifying event, which is the divorce or the date coverage is lost. And again, in this example, we assume the general notice was previously improperly provided. The failure of the qualified beneficiary to provide the timely notice equals loss of COBRA rights. And here we provide some examples of the reasonable procedures the plan must have for the qualified beneficiary to follow. So what happens after the plan administrator has received notice either from the employer or from the qualified beneficiary? The administrator must notify the qualified beneficiaries of the COBRA election rights and obligations. So in other words, the COBRA election form and notice must be provided within 14 days. Now what happens, as in many scenarios, where the employer is also the plan administrator? In that case, the employer has 44 days total to provide the notice if it's acting as both administrator and employer. Each qualified beneficiary has separate COBRA rights, so it's not as if it's an all or nothing thing for all the qualified beneficiaries. For example, the employee could elect COBRA, but the spouse could decline, or vice versa. If the qualified beneficiary has notified the administrator of divorce, legal separation, or loss of dependent status, and COBRA is denied, the administrator must provide notice and an explanation within 14 days. So again, if there's a denial in this situation, that denial notice and explanation must be provided within 14 days. Here again, due to time constraints, I'm not going to cover what's on these slides, but on these slides we provide information about what the regulations indicate must be in the notice which accompanies the COBRA election form. As you can see, it's a very extensive list of information that must be in the notice. And again, we're happy to talk to you about whether your notice is compliant. So here's something new about what needs to be in the notice, is that the Department of Labor has issued model COBRA notices, and relatively recently, updated the model notice to include a description of the marketplace, otherwise known as exchanges, and a statement that individuals may be able to get lower cost, federally subsidized coverage through the marketplace or exchanges. So this information is certainly helpful to the qualified beneficiary. It tells them that they may have a less expensive alternative to COBRA, which is obtaining insurance through the exchanges. This is also beneficial to the employer, because if the individual elects coverage on the exchange, well, then they're not electing COBRA coverage, which many employers, due to increased premiums they might have to pay to an insurance carrier in the following year, really appreciate this information, that this lower cost alternative is available to qualified beneficiaries. So when does the qualified beneficiary have to elect COBRA? It must be within 60 days of the later of the date the notice is mailed or coverage is lost. If the COBRA election is made within the 60 days, then coverage is retroactive to the date of the loss. What if a qualified beneficiary waives COBRA and then changes his or her mind? If this is done during the 60-day election period, the qualified beneficiary can still elect COBRA, but it's not retroactive to the date coverage was lost. It's prospectively, it's forward-looking, effective only. What can a plan, or what can a plan do during the election period? The plan can suspend coverage and then reinstate it if the coverage is elected by the qualified beneficiary. The plan can continue coverage of the qualified beneficiary, or the plan could tell healthcare providers if the person is not covered. Again, just in the interest of time, I'm not reiterating some of the information on the slides. So what are some specific aspects about the type of COBRA coverage? It's the same as the prior coverage. But if the coverage changes for active employees, current employees, then that corresponding COBRA coverage changes as well.
Now I'm going to start talking about the cost of COBRA coverage. And most of you don't have to worry about this. You've got somebody else handling it for you. But we want to go over this so that you understand the concept. And the general rule is that the plan can charge up to 102% of what's known as the applicable premium, the COBRA applicable premium. There is an exception to this rule as well, and that's for a disabled qualified beneficiary If someone's disabled, you're allowed to charge them up to 150% of the applicable premium for the 11-month extension period that you have to offer to disabled qualified beneficiaries. Now, their family members still can only be charged the maximum of 102% of the applicable premium. So it's an individual by individual premium set. The applicable premium is the cost to the plan of a similarly situated participant. And there's case law that helps explain what is a similarly situated participant. It's not perfectly clear, and it varies from jurisdiction to jurisdiction. But the general idea is that for a fully insured plan, it's going to be the cost for that qualified beneficiary that's charged by the insurer. And for a self-insured plan, it's going to be the reasonable cost of similarly situated qualified beneficiaries determined in one of two ways, either determined by an actuary that you bring in to look at your self-insured plan to calculate what that reasonable cost was, or the plan can use the prior 12-month period of costs and then adjust it by an inflation factor unless you've made significant changes to the plan. And again, similarly situated is going to vary from jurisdiction to jurisdiction, but the idea is that a person on the East Coast might not be similarly situated to somebody who's smack dab in the middle of Kansas where healthcare costs might be lower. Now, the initial premium that that person has to pay for their COBRA coverage is due within 45 days of the date that they make their actual election to take COBRA coverage. And generally, the payment has to include all of the premiums from the date that that qualifying event occurred through the date that the payment is due. You have to give the people a grace period, though, however, of at least 30 days. You can go longer, but 30 days is the minimum. So if the payment's a little bit late, you can't jump the gun and cut off their coverage until the grace period is expired. One thing to keep in mind is that the plan can't require payment to be made more often than monthly. Sometimes it's helpful to offer that as an alternative, perhaps a weekly payment plan for people who are hand-to-mouth on their bills, but you can't require it to be done on a weekly basis. Now here's an example of how the payment timing works. And this is usually surprising for people when they kind of see it all in context. Say somebody has a qualifying event on the last day of the plan year. You have a layoff and people are let go on December 31st. There's 30 days for the employer to notify the plan administrator that this individual is no longer covered by the plan. They're no longer eligible. That takes us out to the end of January. Then there's 14 days for the plan administrator to send a notice to the qualified beneficiary that they have the right to elect COBRA coverage. And here it takes us out to February 13th. This COBRA qualified beneficiary then has 60 days to make their election, and that takes us out to April 15th. And then they have 45 days to actually pay, which takes us out to June 1st. So even though this person last worked December 31st, you're not going to necessarily get your check until June 1st. Now here's a point to keep in mind. If you get that check and it's short, you can't just cut the person off from health coverage unless the underpayment is significant. If the payment is significantly less than the required amount, then you can take the position that they didn't pay. And it looks like at this point significantly less means the payment was short by the lesser of $50 or at least 10% of the amount due. If that underpayment is not significantly less, you've got choices. You can either accept the payment as payment in full and move on, take your lumps, or you can notify that qualified beneficiary that the payment was deficient and give them a reasonable time to pay. You have to give them at least 30 days. But again, you can't just cut them off. COBRA premiums are set for an entire 12-month period. Generally, that means you lock it in and you're stuck with that premium, but there are exceptions to this rule as well. First, if your plan is charging less than the maximum, so it's charging less than that 102% of the applicable amount, then you can change your premium mid-year, and that's generally for employers that have a mid-year renewal, costs go up, you would want to increase your COBRA premium as well. You can also increase somebody's premium if they suddenly go on to the disability extension for COBRA, that additional 11-month period that we'll talk about a little bit more later on. In that case, you can raise their premium up to 150% of the applicable amount. A COBRA premium, also keep in mind, it's considered paid on the date that it's mailed, not the date that you receive it. This can make it important to keep the envelope when you receive a payment that's under, or significantly under rather, so that you can prove the date that the premium was paid or not paid. Another thing to keep in mind is that any third party can pay their premium. It doesn't have to be your former employee or spouse or their kids. Even a hospital can do this. And this is something that's kind of interesting to run across, and it can surprise an employer as well. And it happens generally when somebody who was covered by the group health plan decided not to take their COBRA coverage. They don't do anything, or they actually waive it. And then within that 60-day election period, they have a catastrophic accident or illness, and they end up in the hospital. The first thing the hospital asks is whether they have group health coverage, and the employee explains, no, I just lost my job and didn't elect COBRA. The hospital can pay that person's COBRA premium and put the coverage in place because they want to make sure they get paid. Now let's talk about when COBRA coverage ends. This varies depending on the situation. If the qualifying event was the employee's termination of employment or a reduction of their hours, they can get COBRA for up to a maximum of 18 months. If the qualifying event was their divorce, their death, their legal separation, an individual's loss of dependent status, they aged out of coverage eligibility, or Medicare entitlement, and we'll talk about that in a bit, then they get up to 36 months. Now, Medicare entitlement loss tends not to be an actual COBRA coverage event these days because as long as the employee is still covered by the plan, they don't lose coverage when they become entitled to Medicare. So this is less frequently an event for a COBRA coverage event these days. It's not something we typically see these days. Now, the original 18-month period can be extended to 36 months for a spouse or dependent if they have a second qualifying event that occurs during that first 18-month COBRA period. And that second event is one of those under the bullet point of 36-month COBRA qualifying events, the divorce, legal separation, loss of dependent status, or Medicare entitlement of the participant. And that's a second qualifying event that gives them the right to stretch out their coverage period again. Now, the measurement period is from the original qualifying event. It's not from the end of that 18-month period or the second qualifying event date. If the qualifying event is a disability, that 18-month period can be extended by 11 months, as we mentioned already, for both that individual and for their family members who are qualified beneficiaries. Now, in order to be entitled to this extension of another 11-month period of COBRA, Social Security Administration has to give a disability determination. And they have to decide and determine in writing that the disability began before the 60th day of COBRA and before the 18-month COBRA period expired. The qualified beneficiary also has to notify the plan administrator that the Social Security Administration made this determination. So it's not good enough that the COBRA qualified beneficiary comes back after the fact and lets you know that this determination came through. They've got a window of time to do it. And they also have to notify you when they're no longer eligible for Social Security disability as well. Now, events that trigger an early termination of COBRA prior to those maximum periods we just talked about are listed on this slide. The first is obviously the maximum COBRA period ends. There's also an early termination if the last day, on the last day for which the COBRA premiums are paid. So somebody doesn't pay their COBRA premiums, their COBRA coverage ends as the last date for which there actually was a payment, not the date the payment was due. The date that the qualified beneficiary first becomes covered by another group health plan is also a cutoff date automatically for COBRA coverage. So a lot of employers will draft a severance agreement that says, employee we're going to give you some money, here's some cash, but you have to notify us when you become entitled to other group health care coverage, and you're going to lose some subsidy the employer perhaps is providing. It's an automatic cutoff date for purposes of COBRA, so you don't need to be redundant in your severance agreements. Keep in mind, though, that if the person was already eligible for another group health plan's coverage, such as through a spouse's plan, at the time they made their COBRA election, that alternative coverage does not cut off their right to COBRA. The date that the qualified beneficiary first becomes entitled to Medicare after the COBRA coverage starts is also a termination event. The first day of the month after 30 days after the Social Security Administration has determined that they're no longer disabled, COBRA also ends. So they get a 30-day window there to find some alternative coverage as well. And the date the employer and the entire related controlled group of companies terminates all of their group health plans is also a date that cuts off the COBRA coverage period short of the maximum COBRA period window. Now, keep in mind, it's not enough that one employer goes out of business. If any significantly related employer, and they're closely enough related to be in the same controlled group of companies, has a group health plan, the COBRA obligation shifts to that related employer. A COBRA administrator has to provide notice to each qualified beneficiary if that COBRA coverage is going to end before the maximum period. And that notice has to explain why you're cutting off the COBRA coverage early. It has to explain when the coverage is going to end. And it has to explain what their rights are. So if there's a conversion right on the group health policy, you have to explain it as well. If your plan allows your active employees who aren't COBRA qualified beneficiaries to convert their individual coverage when the group coverage ends, then you have to also allow your COBRA qualified beneficiaries to convert their policy. This only applies if the COBRA coverage ends, however, because they've reached the maximum COBRA period. It's not going to apply if they stopped paying their COBRA premiums. And you have to notify the qualified beneficiary that they've got these conversion rights at least 180 days before the end of their maximum COBRA period. So they've got quite a bit of time there to shop for new coverage. Now, some employers offer what we call voluntary coverage as part of a severance package. And what this is essentially the employer is going to provide some type of subsidy to the employee to continue their existing group health coverage with the employer. It comes in different flavors and varieties. Some employers have historically subsidized the entire premium. Some employers have continued paying the same portion of the premium that they used to pay in the past for their active employees. And in a severance agreement, they have offered it to someone who's now a former employee. If your voluntary coverage is identical to your COBRA coverage, it's allowed for you to say it reduces the maximum COBRA period. Your documents just have to basically explain which way you're going on this one. If it's going to offset or not, you have to explain this. So your COBRA period can run concurrently with that voluntary coverage. You just need to let people know what's going on. I wanted to bring up another one of the Affordable Care Act twists, and that's a lemon twist for those of you who don't get my sense of humor. If the employer subsidizes voluntary coverage or COBRA coverage for a limited period of time after somebody's terminated, that's not necessarily going to be in the employee's best interest anymore. It used to be something that was good in the past, but now it can cause that individual to be ineligible for coverage through the marketplace, through those exchanges. When your employer subsidy ends, they're then stuck with that more expensive COBRA coverage until they reach a marketplace open enrollment window. So this is something that if in the past you used to typically give severance packages to employees that subsidize their group health coverage after they terminate coverage, you might want to rethink your strategy as an employer. If the person could go to the marketplace and get a federal subsidy, it doesn't cost you any money, and they may be better off in the end because your subsidy might end at some point, and they may want cheaper coverage through the marketplace anyway. Another thing to keep in mind is that unless you're offering those subsidies to all of your employees, not just your highly compensated executives when they're terminated, you may have a violation of the non-discrimination rules, and those non-discrimination rules have been expanded under healthcare reform. Now let's talk about the penalties for getting it wrong with COBRA. Essentially, there are a couple of different sources for penalties. One is if this person goes to court and they sue you, claiming that you messed up, you didn't give them their COBRA rights. A court has the power to award a penalty of up to $110 a day for a failure to give COBRA notices when they're required. They can also order the plan to provide coverage for the lost benefits if you didn't provide COBRA when you were supposed to. So imagine a scenario where an individual goes to court to sue you for failing to provide COBRA that you were required to provide, and in the meantime they've had a catastrophic illness or injury and they've got $1.5 million in coverage. Your insurance policy isn't going to cover it, even if you've got an insured plan, because you didn't offer them the coverage through the plan. And you're on the hook for those actual costs for the individual employee and their beneficiaries to make them whole. Another source of penalty is the IRS. They can impose excise taxes of $100 a day for failure to comply with any provision of COBRA. And there's a form that you're required now to turn in yourself. It's a self-reported form, 8928. The penalty is also non-deductible. So you have to keep in mind that you not only have to pay this, you have to report it yourself. If you don't correct when you're supposed to, if you don't go through the process of submitting the form and paying the penalty, there's an additional penalty of $2,500 if it's a small failure and $15,000 for serious failures. Now, there is no IRS excise tax. If the violation wasn't something that you could have discovered or someone else could have discovered by applying reasonable diligence, they're not going to trick you into having to pay an excise tax. There's also no excise tax if there was a reasonable cause for your failure to comply and it wasn't something that you just simply shut your eyes to and ignored. Those Form 8928s are due by the employer's tax return date, excluding extensions. So this is another thing to keep in mind, that if you're relying on a tax preparer to submit these types of forms on your behalf, along with your regular corporate tax returns, they're due on different dates, so your tax preparer is not going to be aware of the problem ahead of time, and they're not going to get it submitted on time unless you tell them. And again, the twist on this under the Affordable Care Act is that you are now required to self-report your violations of COBRA. Now I'm going to talk about flexible spending accounts, and this is kind of a tricky concept. COBRA does apply to some health flexible spending accounts, and you do have to offer people COBRA rights in some cases, but the rule itself is kind of convoluted. It's got some math in it that we'll go through. So I just want to go over the general concept first. And the idea is that if the person who has a health flexible spending account is going to be better off financially paying a COBRA premium in order to get the benefit of using that health flexible spending account for the remainder of their coverage period, if it costs them less than it is worth to them to use that actual pot of money, then you have to offer them coverage. That's the general idea. And this bears repeating, that the former employee actually does have to pay a COBRA premium in order to get the right to use their existing health flexible spending account balance. So here is the actual rule. We talked about the general concept. Here's the math on it. And I'm not going to go through it, but again, the idea is that if the employer is subsidizing your group health FSA, they're giving basically employer money to this thing, and financially it's better off for the employee's better off paying the premium just to get access to this pot of money, then you have to offer them the COBRA. Now here's an example of how a health flexible spending account COBRA scenario works. Now say the employee has made an election to contribute to their health flexible spending account $1,200 a year, and then they terminate on June 30th. At that point, they've contributed $100 a month for 6 months, so they put in $600. COBRA for the rest of the year would cost them $102 a month for 6 months, so that's $612. And the COBRA premium, again, is 2% higher than the normal monthly amount. If that employee had already submitted claims for reimbursement to the Health Flexible Spending Account for $400 at the point of their termination, that would mean that of that initial $1,200, they have an unused benefit amount of $800. They only have to pay $612 to get it in premiums. And so in this case, the employer has to offer this individual COBRA coverage for the rest of the calendar year. I'm just briefly going to mention health reimbursement arrangements. HRAs are employer money, and health FSAs are generally employee money. They can also have employer money as well. But a health reimbursement account is subject to COBRA if the annual employer contribution is $500 or more. Health reimbursement arrangements are linked to participation in a group. If your health reimbursement arrangement is linked in participation in your group medical plan. So for example, your medical plan is a high deductible health plan, but you've got a built-in HRA that pays some of your initial deductibles. Your HRA COBRA can be conditioned on also making a COBRA election to take that group medical plan coverage. So you don't have to give people access to the pot of HRA money unless they elect the group medical plan if you've got these two linked. But if your HRA participation is automatic, then you have to offer COBRA without that condition. Now here's a twist that arises under the Affordable Care Act. Instead of offering voluntary coverage or employer-subsidized COBRA for departing executives, employers used to reimburse employees' premiums under a spouse's group health plan or individual policy. This is no longer an option. Under the Affordable Care Act, they're going to treat those employee reimbursements of premiums for an individual policy as a health reimbursement account, and that health reimbursement account is not going to meet the requirements of the Affordable Care Act's integration rules, which are very complicated, or the prohibition on placing dollar caps on essential health benefits. So you used to be able to do this in the past, you can't do it anymore. Now I'm going to dive into the Affordable Care Act's reporting of COBRA. Just to give you kind of an overview of the reporting requirements, these are the IRS reporting requirements on large employers and self-insured plans. So those are the two different categories of employers that have to report. ALE stands for Applicable Large Employer, so I'm throwing another acronym at you. And this is generally someone who's big enough that the Affordable Care Act's pay or play penalties, excise taxes, employer shared responsibility penalties, whatever name you want to call them, those penalties apply to you because you've got basically 50 or more employees and full-time employees, and you're subject to the penalties. So as a large employer, you've got reporting obligations to the IRS. You have to complete a Form 1094-C, which is basically a transmittal form. It's kind of a cover form, and attached to it a Form 1095-C, but you only have to complete a portion of that 1095-C form, and we'll talk about that in a minute. If you're a large employer and you have a self-insured plan, there's some combined reporting you get to do. You might have had to do two separate reports, but the IRS has said there's going to be just one set of forms that has to go in instead. You have to complete the transmittal form, the 1094-C, but you have to complete both sections of the Form 1095-C that I'm going to show you. If you're not a large employer, but you have a self-insured plan, then you have a different set of forms. You have the B series forms. The 1094-B is a transmittal form, and the 1095-B is the substantive form. In some cases, you have the option to elect to file a 1094-C series form instead. Now here's a fuzzy screenshot of what the form itself looks like. I'm going to give you close-ups, but I just kind of wanted to give you the idea that it's not really a big form and it doesn't have an awful lot of questions. But it's deceptive. There are specific codes that have to be used in different places on the form, and we're going to talk about those. Here's a close-up of lines 14, 15, and 16, and those are the operative portions of this form that apply for purposes of reporting whether, as a large employer, you have provided an offer of coverage to a full-time employee or to a person who's now a COBRA participant. 14, 15, and 16 are the areas that we're going to focus on. 14 is whether you've made an offer of coverage, and I'll show you the codes that are your options to use. Line 15 shows the employee share of the lowest cost premium for the self-only coverage that offers minimum value. And basically, this is the way that you represent to the IRS how much it's going to cost the employee for the lowest cost option available under your plan. Line 16 shows safe harbors. If you're saying, I offered them coverage, they didn't take the coverage, but the coverage was affordable, and I've determined that it's affordable because I comply with the safe harbor, you're going to enter a code on line 16, and I'll show you those codes. Here's a list of the codes that are available for line 14. And for our purposes today, we want to focus on 1G, and that is for a COBRA participant. If you made an offer of coverage to an employee who is not full-time for any month of the calendar year, and they enrolled in self-insured coverage for 1 or more months, then you're going to use code 1G on line 14. There are additional codes on here that I'm going to be referring to, but essentially these are codes that apply to all of your employees. They're not unique just to your COBRA participants. And here's a list of the codes that apply for line 16. They're available. And these are important, and I'll show you how you decide between the different options that are available on another screen. But essentially, there is a separate set of reporting for purposes of avoiding the pay or play penalties. All you have to do is make an offer of coverage that meets certain criteria. That reporting obligation is separate from the obligation to report in order to let the exchanges know whether this individual was actually covered by your plan, and therefore they're not eligible for the exchanges. So there are two different purposes these codes are trying to meet. Now, if you're an ALE, applicable large employer member, that sponsors a self-insured plan, you have to report enrollment for any former employee or family member. So you've got someone who's a COBRA participant and a family member, you do have to report them. If you made an offer of COBRA coverage to a former employee because they terminated employment, it's going to be reported differently than if you made an offer of coverage to someone who is a current employee and you offered them coverage simply because there were a reduction in hours. So different codes have to be used at different times, and I've got examples of each in this package of slides. Now we're going to go through some Affordable Care Act reporting examples to show you how this all applies when you've got someone who's eligible for COBRA. In our scenario, we're going to assume that this is an employer that's a large employer and has a self-insured plan. So they've got reporting requirements under both pieces of the 1095C. Now say this employee, Steve, was enrolled in family coverage that provided minimum essential coverage and it meets the minimum value criteria. And those are terms of art that are unfortunately something that we could discuss in another webinar. But for your purposes, if this coverage offers everything that the person has to have in order to avoid the pay or play penalties, that's what we're talking about. So assume this person's enrolled in that family coverage, and on June 15, Steve is terminated and he gets an offer of COBRA coverage. What happens if Steve does not enroll in COBRA, neither for himself or his family? Here's an example of how you have to report that on the 1095C. So from January 2015 through May of 2015, he is an employee. So on line 14, you're going to enter whatever code you use to represent that you really were offering minimum essential coverage that met the minimum value criteria. If you offered it to the employee and the dependents and the spouse, it would be code 1E. On line 15, you're going to enter the employee contribution for the lowest cost, employee-only coverage that meets the minimum value criteria under the plan while Steve was an active employee. So regardless of what coverage he actually had in place, you enter the employee premium for the lowest cost coverage on line 15 through May when he really was an employee. Then on line 16, you enter that the employee did enroll in the coverage that you offered so that the exchange knows that he's not eligible for coverage through the exchange. Then in June of 2015, he's terminated. Starting from that point forward on the form, you're going to have to change your codes. On line 14, you're going to enter code 1H, which means you didn't make an offer of coverage to Steve. And the reason you didn't make an offer of coverage is because you're offering COBRA. You're not offering group health coverage. You're offering COBRA. On line 16, you're going to enter that code 2B, which is basically letting the government know that the reason you're not offering this person coverage is because they're not your full-time employee anymore. And then for July through December, you're going to enter code 1H, no offer of coverage. And on line 16, you're going to enter code 2A because he's not your employee. And basically, this gets you out of the penalties. It lets the IRS know why you're not subject to the penalties. Now let's contrast that with an example where Steve really does enroll in COBRA coverage for both himself and his family. Same background, he's terminated in June, but in this case, for the entire period of January through December, he does have coverage through your plan. So on line 14, you enter code 1E, which is basically letting the government know that he had minimum essential coverage and minimum value available. On line 16, you enter code 2C, saying, yes, this employee really did enroll in this coverage for this entire year. But for January through May, on line 15, you enter the employee cost, the employee portion of the premium for the lowest cost self-coverage. But for the remainder of the year, on line 15, you enter the COBRA premium for that same coverage, regardless of which coverage Steve and his family elected. Even if they chose an opt-up, an enriched plan that costs a little bit more, you use the COBRA premium for the lowest cost coverage. Example 3, what happens if Steve enrolls but not his family? Well, you can see that it changes things. Initially, we had provisions that we could enter all the way across the board from January through December. That's no longer the case. So that lines 14, 15, and 16, you make one election from January through May, and different elections apply from June through December. This is counterintuitive. I could walk you through it, but essentially the point here is to make you aware that every fact scenario changes the reporting, and some of the things that change are just not intuitive. You just wouldn't suspect that this is what the rules require. The instructions on the form are fairly detailed on this, but these examples help, and I have more of them in the package. Here's an example of how the reporting changes when the qualifying event was actually a reduction in hours. The person really still is your employee. They're just not full-time. And they are entitled to COBRA because of the reduction in hours. And again, the point here, rather than going through the details because of time constraints here, is to make you sensitive to the idea that the reason for the qualifying event affects the way you have to report it. In other words, you're going to have to keep track of the reason for each of your COBRA elections. Even though you may have a COBRA administrator that handles making your offers of coverage, your underlying information that you feed to your COBRA administrator is going to have to be more detailed. I have an example in here as well of what happens when somebody who is an employee declines COBRA, and I have examples of a divorce as well. I just wanted to show you briefly part 3 of the form. This is where you list the family members of your employee, because you have to report to the government whether they have coverage through your plan as well. And the reason, again, is because it tells the government whether these people are eligible to go to an exchange to elect coverage and get a subsidy. Now, you can check a box if, I don't know if you can see it on this, but line 17, if you read across about halfway on the screen, if they were covered for the entire 12-month period, you check one box. If coverage changes mid-year, such as is typical in a COBRA situation, you have to use the month-by-month boxes to the right as well. So you report an offer of coverage for a month on part 2 only if that offer would provide coverage for all days of that calendar month. So if you have a mid-month termination of coverage, you have to use code 1H, no offer of coverage, even though you may have made an offer of coverage under COBRA anyway. If you've got a self-insured plan, the rule's a little different. It applies in a different context. You report enrollment information for individuals who are not employees on any day of the calendar year by entering code 1G. So if someone is a COBRA participant for an entire year, because it's, remember, an 18 or longer month period of COBRA, You do have to report it, but it's a little different reporting. You put in 1G. Here's the contact information for Tom Shaevsky and myself. At this point, I think we've gone slightly over on our time. So if you want to, if you have submitted questions, we'll get back to you.
Yes, and want to thank you all very much for your time this afternoon. We certainly hope this information was helpful. And again, feel free to contact Lynn or me with any questions or comments. We look forward to hearing from you and hope you all have a nice day.